we're ready to proceed. I remind you, you're still under oath.
Yes, Your Honor.
Good luck with your examination.
Thank you, Your Honor.
You're welcome.
Detective,
I remind you, you're still under oath.
Yes, Your Honor.
Good luck with your examination.
thank you, Your Honor.
You're welcome.
Detective, we were talking about the images that you recovered, and all this now list of 13 files and these images, you prepared a specific report to send to the detective with that information on it, correct?
That's correct.
And the reason why you did this a second time in August, was that because you had been asked to do it again, to look for further information, or why do we have a second report being provided with additional items? Do you know?
Let me just take a
Sure.
refresh my memory here.
We're on page 259. Well, you said you don't have those page numbers, but there was an initial analysis done on June 20th.
Right, and June 26th was the
The first 7
several
files.
files. June 27th was the internet evidence files, and then August 4th.
Maybe that's just when you completed the analysis that began back in June. Is that maybe?
That's very possible. I seem to recall there was some vacation in between there somewhere, so.
They gave you vacation. Well, lucky you.
Yeah,
But there's 2 separate things that you provided to the detectives. Am I correct in that understanding? The 7 files of interest and then 13 files of interest. Is that 2 different submissions you made?
yes, it is.
All right, very well. And do you recall that there was some secondary request to you that led to you adding 6 more files and all these images that you've talked about?
Quite honestly, it may have just been a continuation, because the initial files in June were June 27th or 26th, I believe, is when the second set of search warrants came in.
Okay.
So that would have been pretty much the month of July before I got back to this. I don't recall what the impetus was to get back to doing that, but it did happen.
Your report talks about having created a report on optical disc.
Correct?
Does that mean simply a
It's
CD?
CD or DVD or Blu-ray.
Very good. All right. And so in August, okay. So in August, the forensic analysis was completed, and then the following notable items were located and bookmarked. So it's possible that the 7 files you provided on a disk back in June was a very quick providing of information, and then by the end of August, which is after you looked at this computer for multiple times, I take it, this is kind of your final list of what you thought might be relevant.
That's very likely, yes.
That'd be typical how you do it. In other words, you're not able to just sit down on one shift if you're working and look through it and say, okay, there's everything.
Right, and as you can see by the number of devices, that there was a lot of things going on concurrently.
Very good. And so would you have any idea how many hours you actually spent combing through this particular device in order to come down to these 13 files and a few images?
Not a clue,
Okay. Would it be more than 10?
probably.
All right. And when you're in the process of doing that, I think you talked about the images, you actually are just kind of looking through all the images, no matter what they are. You just have the image file and you just start clicking, looking at them and see what they are.
There's 2 ways you can look at images. You can look at a specific folder
Okay?
or file, or you can look at multiple folders and files, or you can look at everything.
Okay. All right. And when you did it, did you just have all the images there to go through scrolling?
Generally, the process is to look at those that are actually saved by the user in their My Pictures.
Okay.
or in something that says these are pictures that are associated with the user. And then after that, if the need arises, then you go look further.
Are you able to tell us exactly what you were looking at this particular device?
I can't tell you where they were because I have to see the forensic report, which is on CD.
All right, very good. And you're the one who prepared that forensic report, is that correct?
Yes.
Very good. All right. As to the Lenovo T530, we've indicated that it's on June 28th that you received that, or excuse me, June 25th, you did the acquisition of that device.
Which device again?
This is the Lenovo T530.
Okay.
Are you able to tell us what type of extraction, what level of extraction you performed on that device?
Yes, I can.
What was that?
Okay, on June 25th, that's when I found it was encrypted,
Yes, sir.
and I obtained the encryption key from Home Depot because the device belonged to them,
Right.
and was able to decrypt the subject hard drive and make a bit-for-bit copy using encase.
And when you talk about that encryption key, is that an alphanumeric password, basically?
If you look on my report on June 06/25/14,
Yes, sir.
says computer had full disk encryption, and then 2 lines below that is the key. It's 1, 2, 3, 4, 5, 6, 7, 8 sets of 6 numbers, so it's 48 numbers.
Okay. Your math is much better than mine. Okay, so it would require you to have those 48 numbers to type into the computer just to open it, correct?
To access the hard drive, yes.
All right. And once you were able to do that, then are you able to tell us what level of extraction you performed?
It was an exact bit-for-bit copy of the source drive, of the hard drive from the computer.
All right. And then, I believe you indicated you then ran the IEF as well on this device on the 27th? The Internet Evidence Finder? I think it's the top of the next page.
Correct. On June 27th, 2014, I ran Internet Evidence Finder against that hard drive, against that image.
Very good. And do I understand correctly that you did not actually do any searching of that information you got from the Internet Evidence Finder?
That's correct.
All right. But you did, on the day prior, on the 26th, provide an extract of the IEF containing links to social media, correct?
Correct.
All right.
Yes.
Now, in order to do that, that would indicate, would it not, that once the IEF was completed, there had to be some searching done.
Correct.
Is that correct? All right.
Correct.
And with regards to that searching, do you recall, can you tell us how you actually searched that internet history?
I would have gone into there's a folder called URLs visited,
Yes, sir.
and would type in either Reddit, REDDIT,
Yes, sir.
and or child free, one word.
All right. And why would you have typed in the word Reddit?
I believe that's information I got from the investigating detectives.
Okay.
It may have been something I saw that I may have come across myself too, so I don't know what the source of it was,
Okay.
other than I did that search.
Do you recall if you were familiar with what Reddit was prior to this case?
I can't define exactly what Reddit is. It's a social media site that is items of, areas of interest that people have that they go to research more information about that.
People can just look at almost any topic in the world, if you will, and find somebody talking about it. Is that fair to say?
I'll take your word for it.
Okay. Well, I guess my question is, did you know what Reddit was before?
I didn't. I didn't have involvement in that social media.
So that would indicate to you, would it not, that it wasn't your idea to search the term Reddit, that was given to you by a detective?
It may very well have been.
Can you think of any other place it would have come to your mind to type that in?
It's either me or the detective.
All right, and you were not familiar with it?
I can't recall what the source of that was.
I see, okay. And the term child-free, was that something that also a detective had provided to you, or you just came up with on your own?
It may very well have been that I saw it because one of the areas that Internet Evidence Finder gives you is search terms.
Yes, sir.
Okay, child-free may have been a search term
Okay.
that I noticed, and based on the case, may have then gone and said, are there any more instances of child-free?
You're not telling us under oath today that child-free was a search term, are you? That was used on this device?
I'm saying that could be. It could have been.
I understand. It also could be that someone has gone to a web page which has that in the web address, correct?
More than likely, if it's in the web address, it's been searched in some fashion.
And when you say search, maybe let's be real careful about the terms we use. It would certainly indicate to you that that web page that has that in the address has been up on that computer at some point in time, correct?
Well, let me explain it this way. I can't get to JCPenney unless I type in JCPenney.
Very good.
Right?
Very good. Unless there's a link to JCPenney through some ad or something that you click on and it takes you there, correct?
Correct?
Right. And that link may not always be obvious that that's where it's taking you to, correct?
Not necessarily.
Well, has it been your experience that there are not ways that you click on things on the internet that all of a sudden end up being something you had no idea what it was? Does that happen from time to time?
Being in the industry, I try to make it a habit not to click on things that I don't know where they're going to take me, because inevitably you'll end up with some kind of malware on your system and you're toast.
Good. Very fair.
Toast.
All right. You're smart enough to know better than to do that, in other words.
I'm no smarter than most people, but
Well,
you learn that once you've been burned, you don't do those things anymore.
very good, very good. And so as you sit here today, you can't tell us where you got that term from, but it could have been from a detective, or it may have been something you came across in searching the internet history.
It's very possible. As I say, I don't recall. If I look at the forensic report,
Yes, sir.
it may refresh me.
All right. And you do have access to that, do you not?
I do.
Okay. And with regards to looking through the internet history, the only way to, if that were how you came across it, that would mean you were just scrolling through the internet history to see what the website addresses were, correct?
Yeah, or search terms, or visited URLs.
And in doing, do you recall doing that, first of all?
Recall from a year and a half ago, no.
Okay. Right. And if you had, you would just be looking through that whole wealth of information without restriction as to specific things you were looking for.
Right, there's no limit. I'm just have access to everything.
Very good. All right. And then after providing that information to Detective Murphy on the 26th, you then simply made a copy of the IEF and provided that to Detective Murphy, is that correct?
Correct.
Did you provide him a copy of the ghost of the machine as well, or is that something you would just hold on to?
No, we keep that in evidence.
I got you, all right. And, but that would allow Detective Murphy, or any other detective really who had access to it, to go through the internet history without limitation and see what all the internet history was.
Correct. When I give him the IEF, Internet Evidence Finder results, he
Yes.
has access to everything that Evidence Finder came back with.
Very good. All right. Now, the My Passport hard drive. I believe you retrieved that on June 20th, but you did not actually do the extraction until July the 8th. Is that correct?
Correct.
All right. And would that work you did be related to the same examination submission form that we've already talked about? That you provided a copy of for me?
Yeah.
Or do you know, I guess I should ask you this, do you have a different evidence,
Do I have different evidence?
examination submission form other than what you've already provided me?
Not for that one, no.
Okay.
As a matter of fact, there's one I'm missing for about 6 or 7 devices. Like I say, it's more a courtesy thing than a documentation thing.
I got you. But it does have the Cobb County Police Department logo on it and is an official document created by the Cobb County Police Department, correct?
Created by me.
Created by you. Well, very good,
Yes.
very good. And this helps y'all keep track of what y'all do in the case,
Right,
correct?
it's so that when we get requests in, we can log that so that when an investigator has the next case to go to, they have the information, they go get the evidence, get the search warrant, et cetera.
Very good. And the typed information on here, would that be like the police case number, data request, briefly describe what is to be searched for? Would that be something you type in, or is that something a detective can type in from his office and send to you?
Usually the detective types it in, but we're not averse to doing that for them if they just bring a device in.
All right. If you typed it, you would have gotten information from the detective, correct?
Yes.
All right. And the level of extraction that you perform on the hard drive, is that also bit by bit, bit to bit extraction? Or is it something else?
I believe it's a bit by bit extraction. Let me just, physical exam. Yep, it's a bit by bit copy. It's an exact image.
All right. And this one, you pulled off 15 files of interest that you provided to the detective, is that correct?
That's correct. On August 4th, I believe.
All right. And in your, first of all, let's talk about how you found them. On this hard drive, is that, the report that you get, is that any different from a report you would have gotten off the MacBook Pro?
It would be similar.
Okay. And it doesn't really matter what the operating system is on the device itself. Your technology is creating a similar report from device to device. Am I correct in that?
Correct.
All right. So when you got this extraction, where did you go to look in order to find these 15 files of interest?
Well, more than likely, they were saved in My Documents or some folder that was under the user's name.
All right. You strike me as a detective who's probably very specific and very accurate as to how you do things. Did you note somewhere in your notes exactly where you looked and kept track of where you were looking through this device?
No, as I said, the forensic report has the path of where those files are.
Okay.
And this, as I said, this is my investigative report. The forensic report's on CD because of the volume of the data.
Right.
And the ease of use in viewing the data on an electronic media, because you view it in a browser like you would any website.
Okay.
So it makes it a lot simpler to look at a lot of data rather than trying to get it in a sequential form like this.
All right. When you did the extraction and before you start looking, does it categorize this information into different folders, subfolders, if you will?
If you're familiar with when you use Windows Explorer on a PC, it lists all the folders that are on your system, and then you can click the folder and drill down further and further.
Right.
And that would be what I would do, is get into to find My Documents type folder.
I'm going to show you a document I've shown to the state. And we believe it's not this particular device, but if you'll look at it and just see if you recognize what's being depicted on that document.
Yes, I do.
All right. First of all, are you able to tell us by looking at just that right there what device that screenshot is from, if you will?
It's some sort of Apple device, that's all I can tell you.
Okay. All right. So it's definitely not this hard drive.
Right, this is a mobile extraction. This is not a PC extract, or a storage media extraction. This is a mobile device.
One of the iPhones then?
iPhone or iPad.
Very good. All right. Just looking at that, I'm just trying to make sure we got a picture for the court and for the record as to what you're looking at. When you're looking at, back to this hard drive, is it a similar sort of production that's given, a presentation given to you that you can click and choose from, or is it totally different than that?
It's similar but not exact.
Okay, all right. In other words, the pictures used there wouldn't necessarily be the same picture.
Right, the picture, you won't see the pictures. What you'll see on the left is folder names, and what you'll see on the right, as you click on each folder, it would show you all the files that were in that folder in the similar fashion that it shows on the left.
I got you. Those folder names would include classified URLs, cloud services URLs, Facebook URLs. That sound familiar?
That sounds like an Internet Evidence Finder report.
Okay, fair enough. In any event, the document you got, is that, in order for you to start looking at items that you've downloaded, we got to click on one of these folders to start that process?
Similar, but not like this. Okay, similar, but yes.
Fair enough, all right. As to, since you've got it, I just wanted to be clear for the record. Can you tell us which specific device that came from or not?
No.
We just don't want an Apple device.
Right, it says Apple device right at the top left, so that was the first clue.
Like I said, you're very accurate and capable and smarter than me.
No.
All right. If I could have that back again. I would like to, no, hold on. Does it say how many objections we show in the court this document, just to make sure the court's familiar with what conduct means similar to this, or would that be tendered into the record, or?
You can show it to the judge on that.
I appreciate it.
See plenty of it.
And Your Honor, maybe it's just helpful for me to picture what we're talking about. I think it may be helpful to the court.
Oh, yes, I understand every aspect of this.
I knew you would, Judge. You are a fast learner.
I'll just hop right over there and do the testimony. Thank you for letting me see.
I'll not object on the record, Judge, but,
I'm not going to do that. It's
All right.
in the afternoon, we can all use a smile.
in any event, for this particular device, you got something similar where you're able to pick and choose from different folders to see what's in them, correct?
Correct.
All right. And as far as these 15 files of interest, the first one, you have noted data 127591870. Is there something about that title and that name that leads you to believe that had something to do with child cruelty or homicide? Or did you actually look into that document first to see what it was?
I may have looked at it. It was a unique name that just kind of didn't fit everything else, okay? And it kind of jumped out, and it happens to be a contact list.
Okay. Is that why you looked at it, because it just didn't fit everything else?
Yeah, yes.
Okay, fair enough. And it ends up being an actual contact, as in a phone number's contact or address contact, or do you remember?
I don't recall.
Okay, but when you say contact list, meaning personal contacts?
It had names and some information on how to get a hold of those people.
Very good. And then you've got, I think you indicated before, there's some law enforcement background that you're aware of, and you pulled several of these files, have names related to that, such as 50-round basic police handgun course, APOSTC rate offer.
Right.
I'm sorry.
Yes.
Okay, all right.
We tend to gravitate to things like that, and we see things like that all the time, so.
Very good. And again, that's a personal choice you're making as you're looking at this device, trying to see what stands out to you that might be of importance or relative to the case.
Right.
All right. The all of these, well, drop down to the bottom there. We've got another bit of personal information referred to as capstone couples, correct?
Correct.
And was there something about that indicated to you this might be related to homicide or child cruelty?
Well, the note to the right of that is my note. It's a list of couples in this group, including the Harrises, so that would have been people that knew them.
All right. So again, there's something about the name that led you to believe this was relative to the search warrant, but in looking at it, you thought it might be helpful information to have.
Correct.
Mortgage envelope, do you recall what that was?
I think it was what it states. It was an
Something
envelope to
about-
pay your mortgage, and I know that financial issues were one of the things that we wanted to look for.
Very good. And then also a resume document.
Correct.
Okay. Now, other than this 15 files, and again, and I apologize if it sounds repetitive, and I really apologize if it is repetitive as to this device, is this indicating you only looked at these 15 files, or is it fair to say you looked at many more files, you just eliminated the others as not being relevant for the detective at that
I
time?
probably looked at a lot more files.
And would you have any idea how much time you spent looking through this particular device?
I don't think it was very long. Well, no, I don't have any idea.
All right. Would it be a matter of hours or a matter of days?
I would suspect probably hours.
After you found these 15 files, did you also provide a disk to the detective with those files on it?
Yes, I did.
And was that the last involvement you had with this device in this investigation?
Yes, it is.
All right. And is that the last device that you in fact searched in this investigation to your knowledge?
I believe we've been through all of them, other than, did you talk about the Lenovo T510?
Let's see here. That's a good question.
Because we got that one later.
Yes, thank you. I failed to turn my page here. I have on the T510 that you were unable to copy, and then you got a key and you then copied it.
Correct, because it was
The Home Depot.
Home
computer.
Depot computer, correct.
But you never actually searched any of the items or files or anything in that device, correct?
No, there was, my note is, no notable items of evidentiary value were located.
So that would indicate that you did in fact look through it, you just didn't find anything
Correct.
that you felt was
Correct.
relevant. Did you run the IEF on that device as well? Or would you have had to?
I don't think so. Let me see. Yes, I did.
All right. So again, off this device, you got all the internet information that you previously described that comes with the IEF, correct?
Correct, correct.
All right, and in fact, maybe,
And that I ran on 9/26/2014 and provided the report on 10/2/2014.
all right. Did you said 9/26. On August 26, did you happen to do some work on this? I'm sorry.
Yes,
That's when you got it. And
That's when I got it,
started.
right.
That's right, you indicated that.
and I acquired it on 8/27,
All right.
and then 9/5, I completed the forensics on that. And then I went back on 9/25/26 and ran Internet Evidence Finder against it.
Very good. But did not actually look into any of the files or
No.
any of the information on that device, correct?
No, not, when I ran the Internet Evidence Finder, I just turned all that information over to the investigating detectives.
Very good. All right. And then lastly, you mentioned this DVD-R. You just plugged that into a computer to see what it was?
Just, they're right protected by their very nature, so we just plugged them in. I think 7 of them were blank, and 1 of them was unreadable.
All right. So you testified earlier that you had viewed them and there was nothing of note, but I understand that there really was nothing to view at all?
On 7 of them, there was nothing, and 1 I couldn't even access, so yes.
Okay. Did you try any secondary source to try to
I did.
view what was on it? and weren't
I
able to
tried a
find it?
couple of other alternative applications.
Okay. And nothing was produced?
Correct.
Okay. All right. Give me just a minute, I may be done here.
That is all the questions I have. Thanks, Jeff. Just a couple of topics to redirect on briefly, Judge. First of all, Mr. Lumpkin asked you some questions about the disk you turned over that had some URLs that you found regarding Reddit and child free.
Correct.
If all those were in conjunction with one another, is it possible that you could have gotten that by doing a search for the term child within the URLs?
Correct.
Okay.
Yes.
And if there had been other terms, let's say with Reddit, but not involving child free, if somebody had been looking for Reddit, you would have included those as well, right? If they'd have said, hey, we need to look for anything
Oh,
with
yeah.
Reddit in it, you would have also noted on that, right?
Right.
So by deduction, it would have been something involving child, if that's all that was given was something involving child free, correct?
There may have been more entries for Reddit than the 5 that I selected that had child free in it. As I said, without looking at the forensic report, I don't know how I did that search.
But regardless, the only thing you noted were issues involving the term child free, correct?
Correct.
Okay. And regarding that initial report you turned over to Detective Stoddard, I believe you stated that you thought that a detective had given you that name, Angie K., correct?
Correct. And,
Or somebody in law enforcement had given you that?
right.
Okay. Is it possible, if you were told to go through messages or people who had messaged the defendant on the day of the incident, that you may have noticed that name?
That's very possible, yes.
Do you sit here and know for sure one way or another?
I do not.
Okay. I'm sorry, Mr. Lumpkin and I were discussing cookies during the break, and I was going to ask a question, but
That's
I'll
not relevant to go on camera, Judge.
I'll withdraw that.
There's some in the office.
Can we take a break?
No.
All right. You indicated when we first talked about it that you believe this information about Reddit and child free came from a detective, correct?
Possibly.
Okay. And when we first talked about it, that was your first inclination, and then since we've taken a break, you've now had time to think about it and think it possibly could have come somewhere else. Is that fair to say?
It could have been my own inquiry while I was looking at stuff, while I was looking through the Internet Evidence Finder information.
Right. And this name Angie K., is that somebody on your personal contact list that you were looking for?
In mine?
Yes, sir.
No.
Okay. So no reason for that name to just pop up out of the blue into your head unless somebody gave it to you?
Well, unless it was somebody he was messaging with during the time of the incident. That may have been the reason that one was picked. Because I was looking at phone calls, we were looking at messages, we were looking at contacts, and we were looking for things that happened around the time of the incident. So
Right.
that may have been where it arose from.
But you don't have any information that indicates that that's what happened, correct?
That it was a result of my inquiry?
Correct.
No.
Mr. Lumpkin
This
has
is
that.
Chad.
Thank you.
Next witness.
Detective Phil Stockard.
While he's coming up, scheduling purposes, my Thursday afternoon case, so we could come back on Thursday afternoon. Does anyone have conflict? Y'all can check.
Yes, ma'am.
First witness, please.
You do solemnly swear affirm the testimony you shall give to the court on which you have pending will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat.
Thank you.
All right, state your full name for our record.
It's Detective Phil Stoddard, Stoddard.
You're employed with Cobb County Police Department, the Homicide Unit.
That's correct.
You've already testified in several motions before this court, one being a Jackson Denton, is that correct?
That is correct.
We'll get to the substance of this particular motion, which is the motion to suppress. You're the lead detective assigned to the State of Georgia versus Justin Ross Harris, correct?
Yes, sir.
When did you initially become that lead detective in this case?
On the 18th of June, 2014.
Did you actually respond to the crime scene on that date, and when did you arrive?
I did. We responded out to the crime scene that day. I don't have my notes what time I do. Stand by. I arrived at... It appears 16:50 hours,
Okay. So that's 4:50, is that correct?
or 4:50 p.m.
And who was with you that responded around that time?
Detective Sean Murphy.
He was your second on this case, and you've heard him give some prior testimony regarding the search warrants.
That is correct.
Can you please describe the scene as you and Detective Murphy found it when you were initially assigned as the lead detective in this case?
As we arrived on the scene had been taped off, and I'm talking about Acres Square. It was outside or the rear of Uncle Mattio's Pizza. There was a Hyundai Tucson parked out in the parking lot. It appeared that it had been parked in the middle of the parking lot. The driver's side door was open. There was a sheet on the ground. I was told that the sheet was covering a deceased child,
That being Cooper, correct?
later identified as Cooper Harris.
And at that time, had the defendant been detained?
Yes, the defendant had already been detained. He was handcuffed and in the back of a police car.
I believe you had a brief conversation with him on scene, is
I
that
did.
accurate? And articulate for the court what briefly you were able to get in terms of information that was of use for you in terms of some future search warrants.
We arrived on scene when I was speaking with the arrestee, Ross Harris. As he was in the back of the police car, I just introduced myself, stated that we were there to do an investigation concerning this child, and that we were going to wait till we got up to headquarters to speak with him. Officer Piper did approach me, and Officer Piper told me that when she had approached Ross Harris was talking on a cell phone. He was on the other side of the vehicle, had a cell phone up there. It appeared that he was actually talking to somebody. As she approached her, Officer Folias approached him to talk with him. He became combative with them or refused to put the cell phone down. They asked him to put the cell phone down. He gave him the finger, said, "Hang on a minute." As they went to talk with him some more, he told him to fuck off. At that time, he was detained, handcuffs placed on him. As he was being detained, a cell phone was removed from him and by Officer Piper and given to Sergeant Thorpe on scene.
Was Sergeant Thorpe still on scene when you were there, do you recall?
That is correct.
And did you come at some point to get that cell phone that was recovered from the defendant during his detention from Sergeant Thorpe?
I did.
Very early on in the investigation, there was some investigation into who could have called 911.
That is correct.
Were you able to determine that the defendant did not call 911 and that's not who he was talking to on the phone on scene?
That is correct.
Based on that, did you have any interest in looking on the phone to see who, if anyone, he was talking to at the time uniformed officers arrived?
Very much so.
There's been some testimony about the defendant's demeanor. When you first approached him and talked to him, can you articulate for the court what was his demeanor during the course of this initial death investigation involving his son?
The initial death investigation, he was very calm, collected.
And at some point, was the defendant transported from that scene to Cobb Homicide Unit for an interview about the circumstances leading to the decedent's death?
That is correct.
When the defendant was brought to the scene where the handcuffs actually were removed from him, since he was now acting in a calm manner.
Yes, when he was removed from the scene, he was taken up to Crimes Against Persons office to be interviewed. When he was placed into the interview room, the handcuffs were removed from him.
Prior to going into the interview with him, do you recall whether you had the information about who the 911 caller was, or did that come after the interview?
I believe that came after.
Okay. I want to talk a little bit about the defendant's interview. We've already done the Jackson Deno. You did Mirandize him and at some point and talked to him about the circumstances of his son's death.
That is correct.
And he did initially waive his constitutional rights and agree to give you a statement.
Yes, he did.
Can you summarize some of the important points that the defendant mentioned to you that later became the basis of your request for search warrants?
And to be brief, that he had left his residence at 8:30 that morning and went to the Chick-fil-A. After the Chick-fil-A, he went to the Chick-fil-A with Cooper. After the Chick-fil-A, he drove straight to work. He stated that he does this 2 to 3 times per month, and that is take Cooper to the Chick-fil-A for a father-son breakfast. He stated that he watched YouTube for information on the car seat. He stated that he was going to a movie at 1700 that day. When he was asked what he was doing at the time that he left Cooper in the car, he said he wasn't doing anything. During our interview, he said he watched news report, advocate to turn around. He had watched a video from a vet concerning the heat in the vehicle, and that he had looked up a Chico Key Fit 30 regulations and such on a Key Fit 30, which is the car seat that was in the car. And at the end, he disagreed slightly with the charges.
Okay. Now, let's take those kind of step by step. Did you specifically talk to him about his history that day to assess whether there were things going on in his life that could have been a distraction for him?
That is correct.
And did he articulate to you during that interview on 6/18 of 2014 anything that had caused him any particular distraction?
No.
Did he talk to you about any texts or apps or anything like that that he was specifically using throughout the day?
No.
And in fact, when you asked him whether he was calling or talking, texting with people, did he make any denials about any of those things?
He did.
When you had this conversation with the defendant about news reports and being an advocate for the Turnaround campaign, how did he say that he saw these news reports, or did he articulate?
I believe he said he just watched news reports.
Did he limit those news reports to anything being on TV, or did he specifically talk about something that he saw on the internet?
No.
Okay.
It was not limited.
Tell me a little bit more about the vet video that he mentioned during the during the interview that you had with him at Cobb Police before his arrest.
He said he watched a video. This video was about a vet who demonstrated or talked about how hot it could get inside the car and how an awful way that would be for someone to die, or how awful that would be.
Did he talk to you at all about his personal fears about his son dying in the manner that he did on this date?
Yes, he did.
What specifically did he share with you about that?
Since he came across and said that was his greatest fear.
And did he also talk to you at all about the car seat that was in the vehicle and mention anything to you that was of note?
Yeah, he said it was a Key Fit 30. It stated that he had checked the regulations for it or researched it, and that it would have fit Cooper Harris. It was the right car seat for Cooper Harris.
Did he say how he had researched that car seat for the vehicle?
I believe he said on YouTube.
And why is it that you were talking about that particular car seat and the fit of the car seat during the interview with the defendant?
That was the car seat that was in the car at the time that Cooper had been strapped into during the day.
Okay. And when you were initially on the scene and during the beginning of this investigation, was there anything significant about that car seat in terms of the size and weight limit to you?
The Key Fit 30 would have been 3 inches, or Cooper would have been 3 inches too big for that car seat.
And the last thing that I think you mentioned when you were talking about the interview with the defendant, him disagreeing slightly with the charges. Why don't you articulate for the court
how that progressed such that he made that comment to you.
I don't object unless this is somehow relevant to what was actually provided to the magistrate during these search warrants. Maybe there's a connection, but I'm not aware of what it is, and I ask the state to either make that known or move on to a different area that's actually relevant to our motion.
What's the purpose?
The defense has specifically mentioned the charges that are listed inside the search warrants. There's been questioning over 2 days about which search warrants had which charges that were listed there. I think it's important to ask this detective what charges he told the defendant he was being charged with and how that became the basis for some of the search warrants that were obtained. They specifically raised it.
You can proceed.
Did you understand the question that I asked you about the chronology of the conversation?
Can I just make clear on the record my objection, Judge? There's no issues with the charge on search warrants because the state has given certified copies of those. I'm not questioning that at all, other than what's on the search warrants. So my objection is as to what the defendant, or what he told the defendant the charges were, has no relevance to what was told to the magistrate and what the authority is issuing from the magistrate.
Overruled.
My question to you is, can you articulate for the court the colloquy that you had with the defendant that led to his statement about disagreeing slightly with the charges?
And as we sat in the room, I told the defendant that he would be being charged that afternoon with cruelty. At that time, he started to argue the charges, and at the end, he said he disagreed slightly with the charges.
Okay. Did you also have occasion to conduct an interview with his wife, Leanna, prior to asking Detective Murphy to obtain some or all of these search warrants?
I did.
And describe, if you will, the interview that was conducted with her and whether she said anything of note to you that became the basis of the search warrants.
During our interview, and like I said again briefly, we went over what she did that day. We went over their marital relationship, and she stated that they have normal problems like everybody else. She stated that they had gone through some intimacy counseling. They had problems with intimacy, and they had brought it back down to going to counseling quarterly. She stated that she had been on some depression medications. She also stated that Cooper was a normal, healthy child.
When you were speaking to the defendant specifically prior to arresting him, did you ask him about whether he was having any marital or family issues that could have in any way impacted what happened in this particular case?
Yes.
And what was his response when you talked about that particular topic?
That there are no problems.
That's what the defendant told you, is that correct?
Yes. They had a good marriage.
What about his wife?
She stated there was problems with intimacy.
I want to talk about the iPhone specifically first. When is it that you actually came to be in possession of the iPhone that was taken from the defendant when he was detained on scene?
The iPhone was given to me on scene right before I left the scene and headed back up to headquarters.
Okay. So did you actually have that iPhone with you prior to conducting the interview with the defendant?
That is correct.
Was there an issue about the battery power on that phone that you addressed, and was that discussed with the defendant during the interview with him?
It was.
Why don't you explain to the court what the issue was regarding the battery power?
The phone was on really, really low power. At that time, it was placed on a charger, and it was also told the defendant the same.
You told the defendant that the phone was being charged?
That's correct.
At some point during the course of the interview, did you ask the defendant to consensually give you his passcode to his iPhone?
I did.
And when you asked him to consensually give you the passcode to his iPhone, did he provide it to you?
He did.
At that time, did he in any way, when you asked for the passcode, did he say, I don't want you looking on my phone, or articulate to you that he was concerned about you doing that in any way, shape, or form?
No, sir.
The passcode that he gave you, did that indeed allow you to access the phone? Were you able to confirm that at a later time?
It did.
So the passcode that you asked for, he didn't give you a fictional number or anything like that. He gave you one that did allow you to get onto his phone when you asked consensually if you would give it.
That is correct.
Early on in this case, you asked Detective Sean Murphy to apply for certain search warrants for some things. Is that correct?
That is correct.
When you were initially on the scene, do you recall seeing or noting any electronic devices that were inside defendant's vehicle?
There was a computer bag or a large bag sitting in front of the passenger seat of the car. It appeared that it could hold some computer devices.
And during the course of your interview with the defendant, did you also talk with him about what his employment was and what his specific role in employment was with Home Depot?
I did.
And what did he share with you about that was of note?
That he worked with the computer, the IT department. Web development, I think was the actual word, web developer.
As part of your request to Detective Murphy, did you ask Detective Murphy, even though you had consensually gotten the passcode to defendant's phone, did you ask him out of abundance of caution to also get a search warrant for that phone?
That is correct.
And was part of the reason that you wanted that search warrant to see what contacts the defendant was having with others throughout the day of June the 18th of 2014?
That is correct.
You've heard the testimony in this case and seen the actual search warrant. There was a search warrant that was actually obtained for the iPhone 5, correct?
That is correct.
And included in the testimony was Detective Murphy asking for permission to ascertain messaging contacts from that particular day, the day of the crime. Is that correct?
I believe so.
I want to talk to you about some things that happened before the actual execution or searches on some of these electronic devices. And let's stay with the iPhone for a second. When you initially got that from Thorpe and the defendant consensually gave you the passcode, at that time did you conduct a search of any sort on it prior to obtaining the search warrant?
I did not.
Had you learned prior to getting onto the phone or taking a look at the phone that the defendant was not a 911 caller in this case?
Yes.
A note, and I think the court saw this as well during the Jackson-Denham, at the initial portion of your interview with the defendant, you did something with the defendant's property in his presence. In other words, things that were on his person. Can you describe for the record what you were doing in terms of an inventory of his personal property before the interview began?
It was just inventory. It was just, for my safety, for the, Mr. Harris's safety. See what actually he had on him while we're sitting there in the interview room.
Had the defendant still had his cell phone on him at that time, would that have been part of the interview?
Yes, it would have been removed.
Would you have still sought defendant's passcode consensually, whether you got the phone from Thorpe or from the defendant? Would you have still asked that question of him?
Yes.
And would you have still asked Detective Murphy to get a search warrant for it out of an abundance of caution, whether or not the defendant gave you the passcode or not?
That is correct.
Now, after the defendant's arrest, the property that you interviewed in his presence, his wallet, I think there were some keys and some other things, including the cell phone, did you retain all of that once he was arrested?
That is correct.
And can you describe for the court, is that common that you would keep a defendant's property when they've been charged with cruelty or murder?
Well, it's very common. They cannot take their property into the jail with them, so all the property is maintained by us.
All right. At that time, was there any search that was conducted on the iPhone, the date that he was actually arrested?
I do not believe so.
Okay. Now, I want to talk about something that occurred on June the 20th of 2014. And I'll ask you this first. Prior to that date, had you at least obtained general information about who the defendant had been talking to in terms of call detail and text detail that was recovered from his phone pursuant to search warrant and him having given you this passcode consensually?
That is correct.
And describe to the court in what format or what means did you have this information about the basic chronology of who the defendant had been speaking with by text, phone, or otherwise, and what format did that come to you?
On the 20th of June, we received hard copy paper report, was given to Detective Murphy. It contained the contact for kick subject, Angie K., who's also known as Dark Phoenix 1982. There was a call log for 6/18 2014 through 6/19/2014, and a call log of calls between this device and Leanna Harris.
Was there anything else that was obtained from you specifically from the device outside the scope of what you just mentioned to the court? The basic call and text messages from that date, and then the call and conversations and text between the defendant and his wife?
That's correct. That's it.
That's all you have?
That's all I had was those 3 forms.
I want to talk a little bit about Angie K. on Kick. On the 20th, when you had information in your possession that the defendant was having contacts with this Angie K., were you able to identify and find out who that person was?
I was.
And did you make contact with her on June the 20th?
I did.
To describe for the court how you made contact with her and the significance of that.
On the 20th of June, we were able to do a search through TLO and other RMS, Accurate, normal search engines that we use. We were able to identify Angie K. And a current address for her. At that time, once she was identified on that day, we went over to her residence and conducted an interview with her. Residence is going to be on Shaded Oak Lanes in Marietta. She stated that she had met Mr. Harris through Scout. They had exchanged some sexual in-kind messages. She did deny that they ever met in person. She asked Justin why he was unhappy, and he stated that he really wasn't unhappy. He just didn't get what he needed at home.
Okay. Now, was the information you obtained from her contrary to what the defendant had told you just 2 days earlier in his interview with you?
Yes, 2 days earlier he had said they had a happy marriage.
And were you able to confirm in your interview with her what you had seen in terms of this Kick chat with her username, Dark Phoenix?
That is correct.
I also want to talk about something else that happened on the 20th. On that same date, did you have some independent information that did not come from the phone about the defendant having some inappropriate sexual relations with someone outside of his marriage?
We did.
Can you please describe for the court what independent information you got, independent of the phone, about the defendant's inappropriate sexual relations with persons outside of that?
Your Honor, I object. This has absolutely nothing to do with the motion to suppress. The one bit of information provided to the magistrate is in the search warrants. They testified to the person actually talked to the magistrate. None of this information was given to them. So to attempt to get this in the record and maybe confuse the court about it, I think is inappropriate. It's got nothing to do with this motion. So I would ask the court to limit the cross-examination to this motion so the record is not clouded by this information that has absolutely nothing to do with what the magistrate was told.
In response, I would say it doesn't cloud the record, it clears up the record about independent source and inevitable discovery. If the state can show that there's an independent source for this, it certainly is going to be instructive for the court when you pass upon all of the suppression issues that have been raised in this 30-page motion.
That's going to be a novel argument how that becomes independent source. It certainly, as the state's indicated, has nothing to do with search warrants. So I think it's interesting.
My question to you is, describe this independent information that you, and I'm saying independent of the cell phone, that you received on the 20th and how it is that you came to have this information regarding this individual. We'll call her Chelsea and just call her CD because of her juvenile status.
Yes, sir. On the 20th, we received, or actually around the 20th, it might have been the night of the 19th or the 20th, received a tip from the district attorney's office. They had received information or a tip that this young lady, CD, had been contacting Mr. Harris through messaging services, and that her parents were concerned and wanted to speak with us.
And when you received, did that information come from the phone?
No.
Did that come from any search of the defendant's house or his vehicle?
None.
Okay.
None.
This came completely from an outside source of your investigation?
Yes, sir.
And did CD reach out to someone, or CD's family reach out to someone, as opposed to you all reaching out to her?
That is correct.
Now, once you received that information on the 20th, what, if anything, did you do to confirm it?
I contacted CD. I was able to go through the motions. We figured out who CD was. I contacted her mom, and then eventually contacted her that night.
On June the 20th.
on June the 20th.
And we don't need to get into every single detail, but articulate for the record and for the court the general substance of what she shared with you in terms of her relationship with Mr. Harris.
She had been involved in an online relationship with Mr. Harris. They had texted back and forth and had exchanged photos back and forth.
Okay. And was that when you talk about photos, first of all, are they photos of an explicit nature?
Yes,
And did she confirm for you that she had been actually talking to the defendant leading up to and including the day of the death?
that is correct.
Similarly, Dark Phoenix, did she confirm that she had been talking to the defendant on the date of Cooper's death?
Okay. 6/22. Now, I'm going to back up here real quick with the phone interview. The actual phone interview with Chelsea, or CD, was done on June the 22nd, not June the 20th. I'm sorry. I had the wrong date.
But her initial reaching out to you was on the 20th?
I believe so.
Okay.
And then June the 22nd was the actual phone interview. June the 30th was the interview at her residence. Said, okay.
So the phone interview, did that occur before obtaining the second search warrants for the iPhone?
That is correct.
And did she confirm with you on the phone prior to seeking and obtaining the second search warrant, the defendant's phone, that she had had some inappropriate relationship of a sexual nature with the defendant online?
Yes.
By June the 24th and June the 27th, when we'll call those the dates of the second battery search warrants were issued, this information about the defendant's relationships with these two other girls, was that contrary to what the defendant had told you on the 18th?
That is correct.
And is that part of the reason why you asked Detective Murphy to seek additional warrants expanding the scope of the search of the prior items that had been recovered?
That is correct.
Do you recall when it was that you actually received the CD from High Tech involving the actual phone?
Yeah, the phone, the disc phone, the iPhone was received on June the 25th.
Now, on that date, did you do any actual additional search of it prior to getting the additional search warrant?
It is possible that I opened up that disc. I would put it in the computer and make sure there was information on that disc. I did not do any active or intense drawn out searches.
Now, at that point, you did have an active search warrant that was in place that would authorize you to look onto the device.
Yes, sir.
On the 27th, is that the date that you had Detective Murphy obtain the additional search warrant to expand the scope of the permissible search of the iPhone?
Yeah, the original batch was done on the 24th, as we've gone through with Mr. Lumpkin earlier. The phone was not in that original batch. It was added on the second batch that Detective Murphy did on the 27th.
Just so we're clear for our record, State's Exhibit number 4, search warrant ending 0599. was the original search warrant for the phone, correct?
It appears so.
Okay. And then the 27th search warrant, June 27th, for that phone, that states Exhibit 310660, is that correct?
Correct.
Okay. This second search warrant, on the second page, if you'll read this line starting, Harris also claimed.
Harris also claimed that he is happily married. Nonetheless, evidence of inappropriate sexual communications with other women had been obtained.
You're talking with Detective Murphy throughout the course of the investigation, is that correct?
That is correct.
And as you're getting information that you believe to be pertinent, are you sharing with him, specifically when it comes to you requesting that he obtain additional search warrants?
Yes, sir.
The basis that you just talked about for that particular search warrant, 0660, is that what you just testified about for before Judge Staley involving these two women?
That is correct.
After the second search warrant was obtained, can you describe for the court how it is that the hard drive for these electronic devices came into your possession such that you could actually begin the actual search of them?
We would receive discs from the high-tech unit.
And specifically for the phone in this particular case, you had already received at least one disc, is that correct?
That is correct.
Did you at some point receive a more complete copy of that disc, or is that the one that you worked off of?
That's the one we initially worked off of.
And after the second search warrant, well, let's say prior to the second search warrant, other than looking at the call detail from that particular day that you had talked about, did you conduct any more extensive search of that phone for evidence of any appropriate contacts with other women other than from that day?
No.
When is it that you went back into the phone to expand the scope of the search?
It was after the second search warrant. When you receive a disc from high-tech, you have to save it to your hard drive. If you don't save it to your hard drive, it's very slow, it's cumbersome to look at. You can look at it, but it's not the way we do it. What we do is we take the information from the disc and it's copied to your hard drive. I have my notes, and on the hard drive, it was on my personal computer at work. It was copied to the hard drive on June the 30th. So we received the disc on 25th and copied it to the hard drive on the 30th.
And when is it that you actually started going through the phone in terms of looking for things that were authorized from the second search warrant?
It would have been the 30th or after.
I want to talk about the scope of the searches of the other electronic devices that were initially seized on the 18th and 19th. When you initially received permission to seize those items, did you immediately, once those search warrants were obtained, begin searching through the devices?
No.
Did you conduct any searches of those devices prior to obtaining the second battery of search warrants on June the 24th?
No.
No searches were conducted on the Lenovo, other than the extraction process we've heard testimony about. The
Correct.
actual searching of the devices, that didn't occur before the 24th.
That's correct. And high-tech did their job. It was after, or would have been after the 27th when we started getting discs.
Can you explain for the court why it is that you asked Detective Murphy to come back in and get State's Exhibits 6 through 12 from the 24th, these certified search warrants? Why it is that you asked him to obtain additional search warrants? What was the purpose of that?
Two things. Number one, we had also readjusted the arrest warrant. We had changed it to Crowley II, and the reason we changed it was, Crowley II. The reason we did that was because we received the autopsy report, It was hyperthermia as opposed to what we thought was a lack of water or sustenance in the vehicle that day. It was actually due to heat. It was a heat death. Is what killed the child or killed Cooper Harris that day. Also, the information about now we had the two ladies that we had actually talked to, giving us information concerning the inappropriate relationships that he was having.
Now, and let's be clear for our record here. At this point, y'all have the devices, but other than the beginning of the extraction, the searches had not really been conducted of them, other than what we've already talked about for the iPhone. Is that correct?
That is correct.
Did you, after obtaining the search warrants from the 24th, then begin at some point looking onto the devices for the authorized permitted material, including evidence of problems with the defendant's relationship?
That is correct.
Before we leave this topic and talk a little bit about scope, I want to ask you about a particular video that the defendant had mentioned during his interview, having watched online, involving a car desk. Do you recall that?
Yes, I did.
And at the time of the interview with him, did he articulate for you which device that video could be found on, or how it is that he observed that on his iPhone versus some other device?
He did not.
Based on that, did that impact your request for search warrants for electronic devices for this defendant who admittedly works as a web designer?
It did.
Explain.
We didn't know where this video was coming from. We don't know whether this was a video that was sent to him, emailed to him, watched online, saved on a file, given on a disk. We don't know. And so due to that and due to the news report, we're not sure where the news report was also watched at, and we expanded it. Make sure that we could cover all the devices, because nowadays you can use any of the devices. You can use an iPad, work computer, home computer, phone, to watch those or to look those videos up.
Had the defendant only had one laptop and one iPhone, would that have impacted the number of search warrants you asked Detective Murphy to obtain?
Yes, it would have.
And how so?
If you only have one phone, it would have been one search warrant for the phone, as opposed to he has multiple devices or access to multiple devices, multiple search warrants.
In this particular case, did you actually at some point find and observe that video involving a veterinarian in a hot car documenting what occurs inside the vehicle?
Yes, I did.
And on what specific device was that video found?
It was found on the work computer, the Lenovo T530.
Okay, let's be very clear about that. Where was that specific device taken from initially, pursuant to the initial search warrants?
It was taken from the vehicle.
His vehicle?
It was taken from his vehicle in a computer bag.
Now, we've heard some testimony just a moment ago about that computer being encrypted and belonging to Home Depot. Is that correct?
That is correct.
In addition to it being encrypted, when you were able to open up that laptop, the Home Depot laptop found in his car, did you photograph the lock screen to show that there was some sort of disclaimer about this belonging to Home Depot and being Home Depot property?
Yes, this was photographed recently.
This is State's Exhibit 43, which for the record is 2 plastic sheets, admittedly with 3 photographs stapled together. Is that correct?
That is correct.
And these are fair and accurate pictures that you took of that locked screen showing that this had an advisement that this was Home Depot property, correct?
Correct.
Tender States 4-3.
Just so we're clear, you took those pictures recently, but are you telling us that's what you saw on that computer screen back in June of last year?
No, I did not look at the computer back in June of last year.
Okay. Was it any time last year that you saw that, or just this year?
This year.
It's not relevant.
It's
Doesn't matter, Judge.
relevant to standing. There's already been a question about, a lot of question about the laptop being encrypted and being the property of Home Depot. This confirms the prior testimony that you've just heard about that issue, and I don't believe the defendant has standing. This would tend to prove that.
Well, there's no evidence that this existed last year when they were looking at it. I don't know where in the world it came from and how it got on there. They're the only ones who had possession of it. So unless there's some evidence that that was actually on the computer at the time they looked at it, it's impossible.
We can develop this.
Have you done anything to alter that computer since it was initially seized?
I have not done anything to alter that computer.
And from where did you get that? Where did the computer go once it was seized on the 18th and 19th?
The computer went from, it would have gone either to the CAPER or Crimes Against Persons Evidence Room. From there, it would have gone to High Tech. High Tech would have done their job, their work on it. And from there, it would have gone either back to the CAPER or Crimes Against Persons Evidence Room and down to our evidence locker downstairs.
In advance of this hearing, we were asking you, we being Mr. Boring and I, some questions about this computer. Did you actually reach out to Home Depot to ask them about their laptop computer that you had in your possession?
I did. We knew the computer was Home Depot property. I reached out asking how they knew or how they would tell their employees that it was their property, or if there was any warnings, any forms they filled out. And Mr. Parton, one of the managers there, emailed me back with a snapshot of the screen. I went and pulled this computer, and the snapshot was very similar. I went downstairs, pulled the computer out of evidence, I opened it up, turned it on, and this is the first thing that comes in, that comes up on the computer screen.
And is there a disclaimer or admonition on there that basically says, I'm paraphrasing here, that this is Home Depot property, and by logging on to that, you're agreeing to that?
Yes. And to read it real quick, the information on the system is confidential and proprietary and is available only for approved business purposes. This system and any related information is not to be used for any purpose that is unlawful or prohibited by any policy instituted by the company. And at the end is your use of the system constitutes your agreement and acceptance of these terms.
Did Home Depot confirm for you when you talked to them that this was their property that they had purchased for work-related purpose for the defendant?
That is correct.
Okay. I want to talk a little bit about this.
I'm going to object to the state intentionally violating a rule of evidence by reading into the record something that we've got an objection to, that they're trying to suggest that this was on the computer screen at the time back in last year, so that Mr. Harris would have had to have seen it and known that this is a Home Depot property. He had no expectation of privacy. It's what I anticipate they'll argue. But if someone actually from the police department got on that computer and did some analysis of it, somebody had to have seen it, if in fact it was there back then. I don't trust that it was there back then, unless they've got some evidence to that. I'm going to ask the court to strike from the record. They're reading into the record what's on this document that's not properly before the court.
It's been tendered. I believe it's been admitted. It should be admitted. There's been a foundation for it. There's been no evidence that this item of evidence has been altered. You've already heard testimony from Detective Yeager taken in conjunction with this, that back when he initially wanted to review this laptop, he had to contact Home Depot in order to get the encryption code because it was their device. So this is not something new. That's certainly consistent with what this detective was able to see in advance of this hearing. So I don't think it's improperly before the court. The foundation's been laid for it. It should be admitted and be admitted for the purpose of defeating the defendant's standing, which the defense, by the way, has the burden of establishing. Is one of the areas in the law where the defense has the threshold burden of establishing standing, and if we're able to defeat that, obviously the court needs to be able to see it.
If they had the witness, and they did have him here earlier today, if in fact it was there at that time, to where the court can make that logical leap, that yes, it must have been there when Mr. Harris last saw it, but that witness was here and he never said that. Yeah, he did talk about a code, but if in fact it was true, why didn't we have him, why don't we tender it to him and have him talk about it? Why don't we have a detective now talking about some picture he just took recently? It was tendered. I've objected. The state then attempted to lay a foundation, and then they went in and actually put in all the information into the record.
I was going to talk to you now about the scope in terms of the analysis of the different devices that you have in this particular case. To what degree was the defendant's admission to you that he had some electronics background? To what degree was that a factor in terms of how you were going to assess the search of these devices?
It was a large factor.
Can you explain to the court?
He stated he was a web developer. In fact, they are opening a company to develop web pages. We can assume that...
I object to any more assumptions from this officer or any other Cobb County Police Department officer coming before this court in testimony.
The defense has objected to the scope of the actual searches I think this witness is perfectly capable of explaining to the court why it is he might have looked into certain areas versus other areas in terms of the scope that the defense is claiming was unlawful in their own motion to suppress.
I think his testimony was one can assume, and I sustain the objection, but he can testify if he assumes something. Well,
I appreciate that you're ruling in our favor. Thank you, Judge. I appreciate
I don't
that.
know that he goes that far.
Well, I think you sustain my objection.
I think the record will reflect what I did or did not do.
Let's not talk about what another person might assume, but in terms of your interview with the defendant and his admissions about being involved in electronics, did that impact how it is that you conducted some of the searches, you personally, on the devices once they were dumped or downloaded and that information was provided to you from high tech?
Mr. Harris worked as a web developer for Home Depot. He would have a lot of experience in computers, computer software, websites, computer programs, and would be able to hide stuff on his computer or change it, put it in different files on his computer, easier than a layman.
Once the second set of search warrants were received from the 24th and the 27th, is that when the actual searching of the extracted data from all of these devices began by you and your team?
That's correct.
And it was only after those second series of search warrants from the 24th and 27th?
That is correct.
By that time, had the scope of the permissible searches expanded from the initial search warrants from the 18th and 19th?
That is correct.
And let's talk a little bit about that scope and what you did once you received the items back from high tech in terms of the data that they've extracted. Can you give examples for the court of instances where, let's say for the phone, for example, or the laptop, for example, where there were things that you did not look into or did not delve into because of the scope issue that we're talking about?
If it was something simple, if it was something talking about Kroger or talking about a store or talking about a work email, to where it wasn't scheduling something or a meeting or anything like that, if we took a quick look and it was some work email, we would move on. We wouldn't delve into it. We wouldn't open it up and go further than we needed to.
Could you oftentimes do that in terms of the emails, by way of example, just by looking at the subject line?
Yes.
And did the dates and times of some of these correspondence and things, did that also impact whether or not that would be something you would look into further or disregard it in terms of the scope of your search?
That is correct. If it happened the day of course, we would look into it a little bit further than stuff that happened a week before.
Okay. And focusing in particular on the day of, were there certain items of evidence that you did find from the 18th that was of interest to you when you began the searches of both the iPhone that had been downloaded and the laptops?
That is correct.
And did some of that include contacts between the defendant and other persons?
That is correct.
Was that contrary to some of the things he had told you in his interview with you?
Yes.
When you interviewed the defendant on the 18th, did he say anything to you about whether he had been distracted that day?
He said he was not distracted.
And did he talk to you about text messaging other women outside of his marriage and inappropriate sexual relationship? Did he make any admissions about that on the 18th?
He did not.
Once you obtained these search warrants that allowed for the expanded scope into any marital issues the defendant was having, were you able to find some of that evidence within these devices?
That is correct.
And where specifically did you find most of these?
Most of these were on the iPhone, his personal iPhone.
There's been some testimony about a particular Apple computer that was recovered from defendant's home. And were you able to access that at some point and learn that that actually belonged to the defendant's wife?
We believe it belongs to, or was mainly used by Leanna Harris.
What's the basis for that belief, having examined that in more detail after the 27th of June, 2014?
Her cell phone records, it appeared that her cell phone records had been downloaded on that computer, like on a backup. There was several files. It would say Leanna Harris as part of the file on that computer.
I want to talk a little bit about web history. And were you able to get from high tech once these devices were extracted or downloaded, once that data was provided to you, were you able to look at some of the web histories to make any determination about whether they may be pertinent and within the scope of the search warrant?
We did.
And can you just describe by way of example any web searches that clearly were outside of the scope of what you're searching for, such that you didn't do any further search of those?
SEC refs.
Okay, and just describe for the court what that is and for our record.
And for like SEC refs, any type of, Mr. Harris was a referee. He was very involved with, or appeared to be very involved with reffing high school football or football. Anytime we would see something like that, kind of move on.
I want to talk a little bit about child-free and Reddit and those types of things. Did you see any evidence that was obtained after the abstraction and after the searches began of these devices of those type of evidence involving living child-free?
Yes.
And where specifically was that found?
Those were found on Lenovo.
When you say the Lenovo, are we talking about the...
T530, the one that was taken from his vehicle.
This is the Home Depot, is that
The
correct?
Home Depot.
What
Lenovo.
about the Reddit sites?
Believe the Reddit sites were on the same computer.
Okay. All of these were found on the work computer or Home Depot computer that was encrypted.
That is correct.
You personally were involved in getting 3 additional search warrants in this case in 2015, is that correct?
That is correct.
Let's talk about those for a minute. When was the first search warrant that you obtained?
The state has certified copies, which I believe they do, and they just want to tender them on the check, so that would speed up the process.
Okay, great, we'll do that. We'll tender State's Exhibit 37, search warrant ending 0040, and that will be from January the 8th of 2015. I'll tender State's 38, which is a copy of that disc with a copy of the sworn testimony and your initials on it, correct, Scott?
That is correct.
I'll move on to the second one, and then this will speed things along. State's Exhibit 39, certified copy of search warrant ending 0081 from January 16th, 2015. And then State's Exhibit 40, you recognize as being the disc with your sworn testimony before Judge Taylor, I believe, correct?
Yes, sir.
Tender 39 and 40. And then the final search warrant, State's Exhibit number 41, and that is for search warrant ending 1072. These are all 15W, by the way, from 2015. And then that is from August the 28th of 2015. 42 will be the disc with your initials on it that contains your sworn testimony in support of this search warrant, State's Exhibit 41.
Correct.
Tender 41 and 42 as well.
Objection.
They're all admitted.
Let's take them in succession. The first one that was obtained on January the 8th of 2015. Describe to the court what it is, why it is that you sought and obtained this additional search warrant.
On January 8th, we had gone, well, actually, let me back up just a little bit. After Mr. Harris was arrested and placed into custody, Home Depot that day, before we can even get out there, had gone through and boxed up all his belongings. They had taken his belongings and they had photographed him, taken his belongings and put him into a stored room. We were given the photographs of his belongings, or actually all the belongings that were at the desk. I had gone through those photographs. I did not see at that time any electronic data or any electronic data storage devices. What we did is we kind of moved on. Later on in my investigation, I was going through my notes, decided that I was going to go and photograph those items just to make sure there was anything of note there. As I was photographing the items in the box at the Home Depot, I noticed that there were some flash drives in the box. Flash drives are commonly used to store information.
Ending 0040, I believe the first State's Exhibit I showed.
That is correct.
Let's talk about the one from the 16th of January 2015, the one ending 0081. describe why, about the one from the 16th of January 2015, the one ending 0081, describe why that second search warrant in January of 2015.
As I was looking at the first two, or as we recovered or seized the first two flash drives, we observed that there was a third flash drive in the box that we had not seen that second time, or not seen when photographing. At that time, backed out again when I got a second search warrant to come back in and seize that flash drive.
Okay. And I bit now about the third and final search warrant that you obtained in this case, search warrant ending 1072 from August 28th of 2015.
As opposed to using like our UFED reader and what we have currently. It was called Lantern. And then we decided since the actual phone would have to be searched again for Lantern to be used, that we would go ahead and get a separate search warrant for that.
This involved nothing new necessarily from the phone so much as law enforcement's ability to use some new system that you thought might be more advantageous to getting the data off the phone.
That is correct.
The details for these three search warrants, you provided this information to the magistrate court, is that correct?
That is correct.
And the basic template for it looks like, was this similar to a template that Sean Murphy, Detective Murphy, had been using? Obviously, you made some changes to it.
Yes, sir. That's the same. It was similar to his template.
Okay. But the substance of it that we have in State's Exhibit 41 and then 42, your sworn testimony, essentially the same substance, other than the addition of additional evidence that had been collected since the extraction of the devices and examining them after June the 27th of 2014.
Correct.
Just a moment, Judge. Yes. The phone that you received from Detective Thorpe, did you confirm with him that he hadn't looked on the phone or attempted to bypass the passcode or in any way prior to you speaking to the defendant?
Yeah, Detective Thorpe used to work, or actually Sergeant Thorpe, I'm sorry, used to work in same division I used to, or I do, crimes against persons. He said he'd shut the phone off and did not handle it any further.
Okay. And you did confirm that it was indeed passcode protected, meaning unless you knew the passcode, you couldn't just manually get onto the phone?
That is correct.
Okay. Thank you. I think that's all I have, Judge, at this time.
What's exactly?
All right. Is your testimony, Detective Stoddard, that you did not look onto that iPhone beyond the passcode screen until after June the 24th of 2014?
That is correct.
You obtained a search warrant for it within hours of obtaining it and chose not to look at it.
Yes, sir.
And you indicated that you did not speak to this person known as Angie K until June the 20th.
That is correct from my note.
And do you know what time you spoke with Angie K on the 20th?
Let me see. 2,100 hours.
which is for layman 9 o'clock at night.
That would be 9 p.m., yes, sir.
But yet, Detective Yeager, let me get his, excuse me for one moment. On that same day, Detective Yeager had already, well, he provided to you hard copy reports of that information of Angie K from that iPhone 5S, specifically regarding contact information regarding Angie K, also known as Dark Phoenix, 1982. That's after he has already dumped the phone, doing the analysis, searched through it, and found that information. And you're indicating that he magically gave you that information before you spoke to her at 9 o'clock that night? Is that your understanding?
I don't understand what you're asking.
Okay. Well, I'm trying to figure out, if you didn't speak to her till 9 o'clock that night, how was it that Detective Yeager had already had a chance to look for that information, find it, and put it in a hard copy report to you that same day?
That's how it works. He would look at the phone, find the information, create a hard copy, and then give it to me. I would then investigate it and find her.
So is your testimony that he just picked this out of the blue of all the information that's on this phone, he picked out this name to give to you, that you then spoke to her at 9 o'clock?
Well, no, and once again, he was having, or Mr. Harris was having a conversation with her the day of Cooper Harris's death. So on the 18th, Angie K and Mr. Harris were talking back and forth, and pictures were exchanged, or actually he sent a picture.
This is information that you got later after searching through the phone, I take it? Or did you have it on the 20th?
On the 20th, I knew we had some, I don't have the actual, what he gave me in front of me, sir. So what I'll say is he did give me her name and some of the text. I don't know whether that text actually shows the photo that was sent or not, but that's all I received.
All right. And with regards to any other detective looking at that phone, you're not aware of any other detective who looked at that phone to give Detective Yeager that information?
No, sir.
Now, you indicated that you started speaking to Mr. Harris on scene, correct?
Yeah, it was a real brief introduction.
You got there about 4:50 and you started speaking to the RSD, correct?
Yeah, 1650.
All right. And the fact of the matter was he was not under arrest at that point in time?
That is correct.
But you were treating him as though he were an RSD, correct?
Oh, I did not have all the information, but yes.
Handcuffed in the back of a patrol car, not free to
agree.
leave, correct?
Yes, sir.
All right. And with regards to the phone, you were made aware by Officer Piper that in fact that she had taken that phone from him without his permission from his pocket, correct?
Correct.
And at no point in time did you offer to give the phone back to him, correct?
Correct.
And at no point in time did you actually give him his personal property back, correct?
Correct.
But you allowed him to come back to you had him transported back to the headquarters in a patrol car in handcuffs and brought back to headquarters and then released from handcuffs, correct?
Yes, sir.
And you spoke with him very openly, correct?
That's correct.
He was very calm, as you indicated at that point in time, calm and collected, I think you said?
Yes, sir.
All right. And at no point in time did you give him his phone back,
No.
correct? And, but you ask him at some point in time for the code to his phone, and he gave it to you willingly?
He did.
You never indicated to him that, hey, don't worry, we're going to give you your phone back, correct?
No, correct.
And do you recall indicating, having a conversation with him about getting some contact information out of his phone at some point in time?
That is correct.
Okay. Was that before you asked for his code or after the code?
After, or during our conversation for it.
Okay. But it was after you asked for the code, correct?
I believe so.
Okay. And you allowed he and his wife, after you spoke with him, you allowed his wife to come into the room for them to have contact, speak with one another openly, correct?
That is correct.
Not in custody, correct?
Correct.
And you did not give him his phone back at that point in time, correct?
That is correct.
Now,
And stand by. You said not in custody. He had already been advised that we were going to be taking charges out on him at that time. Because at the end of the interview, I did advise him we were going to take cruelty charges, so at that time, he was in custody. But we did allow him to speak with the wife.
he was allowed free access to have contact with his wife without being in handcuffs or secured in any way.
That is correct.
Okay. And now you're saying he was in custody at that point.
Well, he was in custody. He was not free to leave, but he was allowed to see his wife.
Okay. So prior to the subsequent questioning that you had of him, you're saying he was in custody, correct?
Well, there was no subsequent.
You recall when you came back into the room later and sat down with him and questioned him? We've talked about it before.
Yes, we have definitely talked about it before, sir.
Very good. All right.
Yes.
Now, with regards to the subsequent, well, let me ask you this. The state mentioned CD. She's not a juvenile, correct?
Not at
They
this
referred
time.
to her as such. She's the named person in the indictment, correct? Ms.
That
Chelsea
is correct.
Doster? Okay. So there's really no need to be using initials because it's public information, correct?
Did you say
She's named in the indictment?
Michelle?
No, Chelsea
Yes.
Doster.
Yeah, Chelsea.
Thank you. And you did not actually interview her until June the 30th? Is that
No,
correct?
that is not correct.
All right. Did you interview her on June the 22nd?
That is correct.
That was the phone interview you had with her?
Yes, sir.
And how long was that interview?
I don't have the CD with me, sir.
More than 5 minutes, less than 5 minutes?
I would say more than 5 minutes.
And at that point in time, did you get the information from her regarding Mr. Harris and his love for his son Cooper Harris?
I don't recall.
I don't recall. Well, do you recall when you interviewed her on the 30th, her being very clear that she stated to you over and over that Ross absolutely loved his son?
Yes, sir.
That he had said that multiple times and made that very clear that he loved his son?
Yes,
correct?
sir.
You never told that to the magistrate, did you?
I did not.
You never told Detective Murphy that to tell to the magistrate, did you?
I don't believe so.
Did you send Detective Murphy to the magistrate with this information of there was some inappropriate sexual communications to tell the magistrate that information?
Yes, sir.
Did you advise him, make sure you don't tell him anything other than that, just leave it like it is?
No, sir.
How about this idea of researching that's come about? You did not tell Detective Murphy that Mr. Harris had said he had researched these things, correct?
No, sir. I was in the interview room.
And once these search warrants started coming back, did you look at them to see what information had been provided to the magistrate to
I
make sure it
did.
was accurate?
I did.
All right. And did you ever correct Detective Murphy about that he in fact never stated that he researched these things?
No. On the 27th, the search warrants were redone, expanded to clarify certain points.
Right. But certainly not to clarify that point, because it stayed the same, correct?
It's research.
I'm sorry?
It's research.
It's research, so you buy into that? I'm sorry, you're saying it's research, that's what's on the warrant, correct?
I agree. Yes.
Okay, and I apologize, I'm getting too fast, so let me slow down. As far as the statement in the warrant that says that he stated that he researched these things, you admit, because you were in the interview, that is not what Mr. Harris stated, correct?
Mr. Harris did not state the word research. No.
And with regards to Detective Murphy's definition of research, are you someone who buys into that
I do.
definition of theory? I got you. Is that something that they teach you in police school, that that's what research means, or is
I think it's common sense. If I'm going to put up a ceiling fan, I watch a YouTube video how to put up a ceiling fan. I've researched how to put up a ceiling fan. I think it's that simple.
Okay. So if you watch the news tonight to see how good you look on TV, that's research for you?
It could be. If I was looking to see what questions you posed, what questions I answered, yes, it could very well be research.
But if you're just watching it because it's enjoyable to watch me or you on TV, you don't have to comment as to which.
Yes, sir.
Some people just watch things and they're not researching things, correct?
It could be, yes.
All right. In any event, when you took a warrant, some year later, excuse me, not a year later, into January, then I guess in August of this year, which would have been a year later, you have those up there.
I do have 3 search warrants up here, or actually more than 3. Which one are you looking at, sir?
I'm looking at States 41, which I believe is the last one, 1072.
That should be for the 2 flash drives?
This is for the white iPhone 5. This is the new technology search one, I'll call it.
Okay. Oh, 1072?
Yes, sir.
Yes, sir.
And in that warrant, you still have that information that you provided to the magistrate, claiming that he stated that he researched the issue of deaths in cars on the internet.
Yes, sir.
And with regards to the statement that's also in there, evidence of inappropriate such communications, you didn't provide any further information to the magistrate of the source of that information, correct?
I don't believe so.
You did not provide information to the magistrate of when that information came out.
No, sir.
You didn't provide to the magistrate any date as to when that communication occurred, correct?
No, I don't believe so.
While we're on looking at the affidavit, also the issue about life insurance policy, that Harrison made comments to family members regarding it. You did not alter that or update it in any way, correct?
That is correct.
Did you actually listen to the phone conversation where that was mentioned?
Yes, I've seen the both of them.
All right. And you know that in fact that was not initiated by Mr. Harris, correct?
The first one was not.
And that was a very minor part of a more lengthy conversation, correct?
It was brought out, but it was a part of a 30-minute interview or a 30-minute visitation.
And you never explained that to the magistrate, correct?
No, sir.
All this information regarding phone calls made on the 18th, excuse me, or communications to whomever, you did not relate that to the magistrate, did you?
I'm sorry, please ask that again.
Sure. The communications that you testified to, you went through a long, lengthy explanation there about communications that were had on the 18th between Mr. Harris and either Angie Kay or Ms. Doster.
Okay.
That did not come up in your speaking with the magistrate, is that correct?
I don't believe so.
The new technology that you had, what was your understanding as to what that new technology was?
My understanding was this is another way to process or pull the information from the phone and to process the information.
All right. And did you think it was somehow a way to get additional information that was not available the first time it was searched?
Yes, sir.
All right. And did that turn out to be the case?
I don't know yet.
Okay. Is that because you haven't looked at that information yet?
We have not received a disc. There were some technical difficulties while doing that. We have not received a disc from High Tech yet.
Now, you took this information to this Angie Kay. Did you know her prior to June 20th, 2014?
No, sir.
And you met with her at 9 o'clock at night and spoke to her about a relationship she was having with Mr. Harris, correct?
That is correct.
Or at least communications, I guess, at least. And she said that he told her that he was unhappy, correct?
Correct.
All right. Now, you're certainly not vouching for her reliability, are you?
No, sir.
All right. So just because she claims that that's what he said to her, that's not necessarily disproving what he said to you. Is that correct?
No,
All right.
but it doesn't prove it either.
I understand that. Regardless, you didn't bother to tell the magistrate one way or the other, correct?
Correct.
In talking about the scope of the search, once you decided to, well, the search was already done on the phone before the 20th, before you got the second warrant, because it had already been downloaded and dumped, correct?
That is correct, sir.
When you got the second search warrant, was there a second downloading and dumping of that phone?
No, sir.
All right. So what you actually began looking at was in fact the initial search warrant downloading and dumping, correct?
Correct.
And when you looked at that, tell us, how did you go about doing your searching of that device?
We went about searching the device. I started with the day of, looking at what he did the day of. After that, after I started looking through that, and that included everything from emails, internet history, his calendar.
Well, let's do it one thing at a time.
Okay.
And if you have notes that have it real specific, that'd be great. If not, I
All right,
understand.
we'll start with this. We'll start with the calendar.
Okay.
Calendars, especially online calendars, have reminders, what was going on that day.
Right.
It also can add to distractions. It could say he had a meeting, he had this, he had to go to somewhere. Distractions, something that's going to make him forget Cooper in the car. It'll have a to-do list, things he needs to pick up, stuff like that.
Is that what, you saw all this on his phone? Is that what you're telling us?
No, that's what we were looking for.
Okay. My question is, what did you do? When you opened the phone, you went to the calendar, we're going to start there.
Yep,
And you went where?
to the day of,
Okay, which is June 18th.
which was June 18th.
All right.
And I started my search there.
And what did you see on the calendar for June 18th?
I don't recall.
Was there anything
I had
there?
nothing of note at this time.
Nothing of note. Well, did you have personal information there?
I don't remember.
This relates to the search warrants.
It goes to the constitutional right he has to be protected and his privacy protected. If the police department is looking into his personal life and looking into all these things, have nothing to do with this case, that's exactly one of the points of our motion to suppress. That they're improperly, unconstitutionally exceeding the scope of a warrant, because they're just looking at anything they can find, and they don't care if it's personal or not. So that's why I'm asking.
And we're going to split every here?
I don't have many left, Judge, but I'm going to do the best I can.
You don't, so don't split them.
Let me ask the next question, see if it does that,
Sorry,
Judge.
open the door.
I'm not sure, I'm sure what Your Honor's saying, but I'll try my best.
Try your least.
Well, I'm not allowed to do that, Judge.
I know that, but there's a point where it's reasonable and not reasonable, and I'm trying to discern where that might be.
Thank you very much.
Thank you.
Once you looked at the 18th and found nothing of note, did you continue to look into his calendar in other days?
I would look for a few days prior.
Any idea how many days prior?
No. Less than a week.
All right. Once you left the calendar, where'd you go?
Text messages.
All right. And when you...
Or we'll just say, actually, we won't even just say text, we'll say messages.
Okay.
Because it comes up on the phone as chats, and it comes up, there's like two different files. There's a chats file that has the kick, well, all these what we're talking about are kind of in there, and it also has text messages, and it also has SMS messages on the phone.
So the category on the device you're looking at, or as you're looking at on your computer, it just has it labeled messages, correct?
I believe it says chats.
Chats. Okay.
Yep, there's chats and SMS messages.
All right.
And this is the file that, or the, not the file, but the UFED reader, the opening screen.
This is how it's presented to you in its organization, correct?
Yes, sir.
All right. And when you open that up, what does it provide to you? What do you see?
Yeah, you can see Kik, you can see text messages, I believe you can see other messages.
Basically, any message that's on that phone, you'd have access to immediately, correct?
Yes.
All right. And then did you just start scrolling down and read through to see what they were?
And once again, yes, we started with the day of, and then we expanded out, went out to a week or more.
How were you able to get to the day of? Is it
You
a
look-
chronological list?
You look at the date.
Okay. Is it in order by date? That's what I'm asking.
I think you got to kind of play with it a little bit. You can get it to, by date.
Okay. When you say play with it a little bit, I just want to be real clear here.
Well, what you can do is you can kind of click up top and it'll kind of organize it for you. You can start like with the day of.
Okay.
And I believe it's different for every time you open one up. Like Kick. If you open up Kick, you got to go through each, put it as chronological order.
Is Kick in its own box, or is it just in the messages box?
It's everything is shoved in this one file, and you open it up, and then you'll have Kick and text and stuff, and it actually comes up two different ways, because you open up one and it has everything shoved together, and then later on you can find it somewhere else on the phone, shoved in this nice little neat package. It's not easy to just kind of go, okay, I'm just going to look at one little piece here.
Okay. So when it's not easy to do that, you just had to start looking through multiple things, correct?
Yes, sir.
And in doing so, that gives you access to all sorts of personal information of whoever's device it is, correct?
Yes, sir.
Okay. In other words, it doesn't have it labeled as child cruelty information, homicide information, medical information, religious information.
That is correct.
You just had to start reading through his life to see what it was till you could find out something that you wanted to find, correct?
Yes, sir.
And you said you didn't limit it to the 18th. You went to several days prior on that as well?
That is correct.
All right. After the chats, what did you look at, if anything else?
Well, we looked at chats, we looked at emails.
All right. And does that category open up similarly to the chats?
I believe so.
And did you again start perusing his personal emails, trying to see what you could find?
I did. Like I testified to before. If it was something like, Kroger having a sale today, and we would go beyond it.
But you wouldn't know that until you looked at it, correct?
Well,
Start reading it.
you can see the subject line on a lot of them. Some of them have a subject line, some of them don't. But if it had a subject line, or it was to where I could tell what it was, and then we would go to the next one.
Okay. So you didn't look at Kroger. What else did you not look at?
I'm using Kroger as an example, sir.
Oh,
Okay.
so that's not
If it was
accurate.
something, no, it could be accurate. I believe there were some Kroger emails on there.
Okay, all right.
If it was something not related to my search, or that I deem related to the search, I would go beyond. I would just go to the next.
And basically, you were the arbiter to decide whether it was related to your search or not.
When I'm searching, yes.
All right. And what the search warrant gave you authority, you understood to be any emails and communications he'd had.
What I understood it to be is anything leading to the evidence of cruelty to child and homicide.
And so you found an email indicating that he had been committing cruelty to children?
And we found an email that stated that from his work or from the daycare, talking about Cooper that day, or talking about that daycare that day. I'm not exactly Cooper, but talking about the daycare.
Any other categories you decided to peruse?
Phone log.
All right. And again, similarly as you testified before, you got it in date form, you started with 18th.
Start with the 18th. We start from ground zero.
You just started tracking all of the phone calls, phone log information that was made to and from the phone?
Yes, sir.
And how many days did you go out from there?
I'm going to say a week. It could have been a little bit more, but we started with the day of. And as we got further on, it wasn't as getting each and every phone call. I started looking for specific numbers.
Okay. Because after you were getting each and every phone call, you were researching all of those phone numbers to see who they were?
Yes, sir.
Okay. And you decided at some point there's some of them that you wanted to look into further, and you started looking for those particular numbers?
Yes, sir.
Your search warrants, in the box where it says information of person to be searched, I'm sorry, in the list of property, articles, items to be searched, has specific instruments, but does not have a list of what you're supposed to be looking for, correct?
Which warrant are you looking at, sir?
I'm looking at specifically at states 41, states, I'm sorry, that's 1072.
Okay.
0081, I think you still have the other one up there with you, 0040. In other words, let's just do one at a time. 1072, I'm starting backwards.
That's good.
1072, on the search warrant, authorization is list of property items, articles, interests to be searched. There's a white iPhone 5.
Yes, sir.
There's absolutely no limitation as to what you're to be looking for in that white iPhone 5, correct?
Correct.
Similarly, in 0081, search warrant for the RIDATA, RIDATA